So welcome to everyone joining us around the world for the Chartered Institute of Arbitrators Ciarb's annual Roebuck lecture, which will shortly be delivered by Dr. Kabir Duggal. My name is Catherine Dixon and I'm Ciarb's Director General. I take this opportunity to warmly welcome you all, but also welcome Kabir and Ciarb's President John Bassey. It's wonderful to be able to host this lecture face-to-face, whilst also allowing Ciarb members from around the world to join us virtually. The title of this year's lecture, in memory of Derek Roebuck, is International Arbitration Versus Human Rights, Armed Conflict and the Environment. Why should I care? Safeguarding human rights, mitigating the impact of armed conflict, preserving the rule of law, and preserving our planet in the face of climate change are some of the most pressing challenges for us all, including for dispute resolvers. International arbitration and investor-state arbitration used to resolve international disputes have become our first, last, and sometimes only line of defence. Today's lecture explores what role international arbitration can play in addressing these challenges, whether international arbitration is helping or hindering, and whether mediation and adjudication can assist. Can international arbitration act as a good neighbour by supporting international law to enable the international dispute resolution community to emerge stronger and promote a better regime for all? I know that this topic will prompt many questions, and I'm looking forward to hearing Kabir's lecture and the questions and answer session afterwards. Just before I introduce our speaker for the evening, a few housekeeping issues. John Bassey, Ciarb's president, who is a barrister, attorney, multi-jurisdictional Supreme Court appointed arbitrator, chartered arbitrator, management accountant and justice of the peace, will be asking Kabir questions at the end of his lecture and giving the closing remarks. If you're online and have a question, please put it in the Q&A box, ideally not in the chat. Please use the chat function to chat, maybe tell us where you are from, why you are part of Ciarb. It's always great to hear from our diverse audience at these events, and always welcome to hearing from our members. John will try to get through as many questions as possible, but please don't be disappointed if we don't have time for your question. For everyone in the room, in case of a fire alarm, please follow the instructions from the staff, evacuate the building. The meeting point is in Bloomsbury Square Gardens. It now gives me immense pleasure to introduce Kabir. Kabir is an attorney and chartered arbitrator at Arnold & Porter, New York. His areas of focus are international investment arbitration, international commercial arbitration, and public international law. He's published 60 articles and is listed as a thought leader in international arbitration by Who's Who Legal. He's passionate about diversity, equality and inclusion, and co-founded REAL, the Racial Equality for Arbitration Lawyers, a non-profit organisation to improve representation in international arbitration. Kabir is also a lecturer in law at Columbia Law School and acts as a consultant for the United Nations Office of High Representative for Least Developed Countries on the creation of a novel investment support program. Kabir works closely with the US Department of Commerce Commercial Law Development Program and has also conducted training and capacity building sessions for several governments on public international law and dispute resolution matters. Kabir is admitted to practice law in New York, the District of Columbia, England and Wales, and in India. Welcome, Kabir, and thank you for taking the time to speak with us this evening. Kabir, thank you.
Welcome, everybody. Thank you for joining us. I'm going to ask a question that I've never asked in my life. Can everybody hear me? My mom is convinced I swallowed a loudspeaker when I was growing up, but we'll put that aside for the moment. Let me just begin by thanking everybody for showing up. There's apparently a viewing room in New York. So hi, New York people. This very sexy title, we'll give full credit to the Chartered Institute. I had the broad idea, so I begin by thanking them. They've really played a very pivotal role in putting this together. Whenever I logged into LinkedIn, I saw a post with my face, and that was strange, a little awkward, but also flattering. So thank you very much for that. Few shout outs before I begin. John Bassi, thank you. Mohammed Abdel Wahab. Ambassador David Hubner, I don't see him. He is there. He begins his speeches with very profound statements in the Maori language. I don't know that, but we're here to talk about, I think, an interesting topic. And I begin on a depressing note. If you have been looking at the news, things look sad, right? You're talking about armed conflict. We're talking about the climate crisis. We're talking about the existence of our species, artificial intelligence, ChatGPT and how it's going to take over everything that we do. I did, for a fun second, actually put my title in, and it did give me 3 paragraphs. I am not using those, but it is sophisticated enough to do that. What role does arbitration have to play in this regard? Now, before we get there, what does the international scene look like? And it's pretty complicated. You have many different areas of international law. You have different priorities. You have the law of war, which is different from the law in war. You have international criminal law statutes, right? You have climate change agreements. You have an entire nexus of human rights treaties. You have trade agreements. You have pure public international law. And then we have international arbitration. Okay, so the regime gives us many different options, many different avenues. Not all of these regimes share same foundational values. They have different preferences and different priorities. And why is that significant for us in arbitration? It is significant, and I'm going to steal Catherine Dixon's line, because arbitration often gives us a mechanism to enforce rights. We're going to be looking at 3 regimes very soon, but these 3 regimes do give you avenues, often avenues without very firm teeth. So arbitration by default becomes a very strong mechanism to enforce these rights. Now let's just look at this. Arbitration can implicate human rights, and I'm talking about arbitration at large. You'll see the presentation will very soon take an ISDS investor state arbitration focus, but a lot of what I'm saying could apply equally to commercial disputes. Your dispute between Mandi and me can implicate things beyond just Mandi and me. It can implicate principles of human rights. It can implicate the environment. We have Lucy Greenwood. I'm just giving a shout out to the Campaign for Greener Arbitrations. Google it, it's a really cool initiative. But the environment presents a very pressing problem, something we need to think about. I'm going to hone in on climate change, just that is our existential crisis. And something that we had hoped would not really become such a big issue, but very tragically armed conflicts. And I'm just giving you 3 illustrations here about how an arbitration dispute can involve commercial/property rights and broader principles. Philip Morris versus Uruguay, right? We're seeing in this case an investor invoking rights under a treaty. We should be free to package things the way we deem appropriate under our patents, versus broader principles of health. You look at Urbacare versus Argentina, we're talking about the right to water versus an investor's rights under contracts. You look at Bear Creek versus Peru, we're talking about indigenous communities versus property rights. How do we resolve these tensions? How do you resolve different regimes that are coming into play and interacting with one another? Before we get there, let's just look at these different priorities or different underlying values. And we're going to look at international human rights law. We're going to look at the law of war that's going to break up very soon into a few different areas, and then international arbitration, right? The consensual method, dispute resolution, can be commercial, can be investor state. How does this implicate these? Okay, let's begin with human rights. Now I'm going to put this typology. It has existed for some time. It arose in a very different context. Okay. Can you hear me? Okay. It arose in a very different context, but I think it provides a very valuable framework for us to be thinking about. You have civil and political rights enshrined in the ICCPR, the Covenant on Civil and Political Rights. That becomes one major set of human rights principles. You're really talking here about negative rights. The state shall not infringe the right to life, the right to property, speech, all these rights. Most of what we're concerned with in arbitration, because arbitration often, we are talking about contractual rights, property rights, would fall as a subset within this bucket. But there are other areas of human rights that are equally important. You have socio-economic rights. These are contained in the Covenant for social, cultural, and political rights, social, cultural rights, social, economic, and cultural rights. These are things, positive rights, the right to health, right, education, labor. And as we saw Philip Morris, right, when you're talking about plain packaging laws, it is the right to health, a right under this bucket getting implicated with, if we want to characterize the arbitration rights as property rights, a right here. You're seeing a tension between both of them. What right are we going to prioritize? And then you have third generation rights. Third generation, these are collective rights. These are rights that exist for all of us, right? Things like the environment, cultural heritage, indigenous communities' rights. This typology is sometimes criticized because it may indicate a hierarchy, and I just want to emphasize, if you truly believe in human rights, every right is a human right. We're not trying to say one is superior to another. They are all interdependent, indivisible rights, right? This gives us, I think, a good framework when we're thinking about rights as to how we should be conceptualizing them. Where do tension points arise? Now, since we're talking about the environment, we're just going to hone in a little specifically on climate change, right? And the two major agreements that we have. You have the UN Framework Convention on Climate Change, and the key principle here is the precautionary principle. If you believe something is going to harm the environment, adopt precaution. That's what the precautionary principle tells you. I'm just going to pause here for a hot second. Arbitral tribunals have, on the whole, been very skeptical about applying this notion. Right? This is a real area of tension because what the Framework Convention tells us, and it is a Framework Convention, doesn't seem to be reflected in the practice that we're seeing coming out of tribunals. So that's one instrument, and then we look at the Paris Agreement. The Paris Agreement really is something that countries own their own set standards with the goal to try and limit temperature to 1.5 degrees. That's the magic number. You, a country, come up with whatever framework you want to accomplish this goal. If we believe the BBC, we have probably already hit a point of no return, which is depressing, but we still got to do better, right? This is going to be a problem that's not going away anytime soon. So just keep this as a specific form within the third generation rights is something we should be thinking about. Priorities here, if you're going to adopt a purely formalistic approach, may have a very different implication based on the lens you adopt. Okay, and now we're going to look at the jus ad bellum, the laws of war, and contrast with the jus in bello, the laws in war. Never have prepositions been so significant. One of the first things I learned in Latin was the phrase, quid Latine dictum sit altum sonatur. If you don't want to memorize anything in Latin, this is a good one to memorize. It roughly translates as anything in Latin sounds profound. So this does have some significance for the purposes we're going to talk about, because the laws of war come out really from just two articles in the United Nations Charter. Okay? Article 2.4 and Article 51. And yes, something can be 2.4 and really significant. It doesn't have to be 2.1. But 2.4 tells us you are not going to use force. There is a prohibition on the use of force in any manner inconsistent with the United Nations. Right? So there's a prohibition on the use of force, with one exception. And that is Article 51. Article 51 tells us force can be used in limited circumstances for self-defense. But the important caveat here is it is going to happen through the Security Council's ultimate approval. Right? Now, if you don't know much about the Security Council, there are 5 countries, including this country, that have a permanent veto. So it was a stupid idea to have begun with if you believe all countries are independent. But you can imagine a situation where one of the 5 countries is itself involved in a war and they have an absolute veto. Sound familiar to the situation we are in? Right? But that's the mechanism. The mechanism ultimately is that the Security Council will decide how to maintain peace and security. Right? It worked well till it didn't. This becomes the framework for the laws of war. Again, for anybody following ISDS, the number of cases involving points of tension today, right? Ukraine and Russia, Armenia and Azerbaijan, that implicate some of these concepts is staggeringly high, right? I think the 10 cases, Ukraine, Russia right now, there's already a case, Armenia, Azerbaijan. You know, we're really talking here about meta questions about is international law being respected? But that's where we are. The laws of war are contrasted with the laws in war, the jus in bello. And this really comes out from the 4 Geneva Conventions and the 3 related protocols. Now, this area of law, we euphemistically describe it as international humanitarian law. There are 9,000 treaties signed in Geneva, 3,000 in The Hague. The 4 big ones are the 4 Geneva Conventions that we are concerned with. What are they really trying to do? The laws in war move on the assumption that if war happens, how do we limit its effects? Right? So although we just saw that you cannot use force, there was some realism in that the regime here tells us that if a war happens, how do we limit it? And the regime actually talks about armed conflict to countries, but it also talks about civil war. Now, some of the things that you're trying to accomplish through these conventions, they're very detailed. If you cannot sleep in the night, I would strongly urge you to take one of the Geneva Conventions and start flipping through them. It helps. But at a high level, there are two values that they're going to tell you. You want to try to prohibit people who are not participating in hostilities. Right? You don't want civilians to become casualties, to become proxies in war. Health workers, right? Aid workers. You want to give these people special protections. You also want to prohibit harms on people who were active but no longer participating in hostilities, right? The wounded, the sick, the shipwrecked, prisoners of war. We're trying to regulate how all this would be addressed. Okay? How do you enforce this? Now, if you were looking for a super robust mechanism, they're going to capture somebody and they're going to get prosecuted, none of that's going to happen, right? This is going to be national laws, diplomatic channels, go to the UN, right? The UN Security Council, we discussed the wonderful veto power. The other thing is the General Assembly. One country, one vote. They will write a very strong letter telling you we condemn your actions, and we leave it at that, right? You could investigate through these criminal courts, the Rome Statute created, right, the International Criminal Court. Again, a state has to voluntarily consent. I leave it at that. Okay? Just on the human rights. So human rights, there are about 7 core covenants for conventions. All of them have created committees to monitor, at a very high level, the human rights bodies. They work on consultative basis where countries will give reports, some certain non-profits can give reports, the committee will look at it and tell you whether you are compliant or not compliant. It kind of ends at that, right? The regime isn't super strong if you're looking at robust enforcement mechanisms. Arbitration offers a very robust mechanism, and so you see a lot of these issues coming into our foray through arbitration. Okay, clash of rights. We recognize that they're going to come into arbitrations. Those are cute. But how serious is the threat of human rights appearing before arbitration tribunals? It's serious enough that the High Commission, the UN Human Rights High Commissioner, put forth a statement saying the Canadian-European Treaty is flawed and nobody should sign it. Right? I mean, I just do want to point this out, that the tension is real. Now, for most arbitration practitioners, most of us who love this area, we believe we are doing the right thing. We're trying to analyze and do the best we can with the tools available. If you are in a room with 100 people and 99 say there is a problem, the one person who may be correct will often get ignored. And more importantly, states are going to feel obligated that they have to do something. Okay? That's sort of where we are. Now, I want to give you in the next 2 slides just 2 very definitive areas of tension, so you can really see how some of these issues come up. And the first is the first ICSID case, right? The first ICSID case under a treaty, Asian Agricultural Products Limited versus Sri Lanka. I think in the UK, you all call that prawns. In the US, they're called shrimps. pretty much the same thing. I'm a vegetarian, but people who eat them say, call it what you want, it's delicious. What's happening in this case? You're having a civil war, right? You're having the Sinhalese government, you're having the Tiger rebels fighting. I always imagine this in my head because the war is happening and there's a shrimp farm in between. Nobody wants to target the shrimp farm, but the shrimp farm gets destroyed in the cross-fighting between these two groups. The investor, actually a British investor, invokes the Sri Lanka-UK treaty alleging breach of full protection and security. You're talking about an armed conflict, right? Now, this is a civil war, but we have provisions that regulate this. But that's the framework we have, and the investor is saying, you have destroyed our investment, the full protection and security clause is violated. Now, this is a very interesting case because unrelated to today's presentation, but one of the big areas of tension is how do we get more women involved in arbitration? How do we make arbitration more geographically representative? This is a rare case because you actually had an African arbitrator involved. So apparently things were okay in the beginning. Somehow along the way in the exits journey, things went horribly wrong. But the majority comes out telling us, look, there's no strict liability, but Sri Lanka, you could do better. And so they actually obligate Sri Lanka to pay money, right? Now, it is arbitration. You have to convince 2 out of 3. The dissenting arbitrator comes out telling us, no, this is a civil war. And pretty prominent and well-regarded scholar tells us there is no rule in international law when 2 countries are fighting that you have to pay money. So again, you're seeing here an armed conflict situation directly coming into arbitration, 2 very divergent views in the same case. I'm going to give you, after this, probably the case that we have been talking about quite a bit, Philip Morris. Now, the case comes about here at a very high level telling us cigarette packages must 75% of the package must be pictures of people dying, right? Cancer, right? The idea, this moves on the premise that if you do this, people are going to look at it and not want to smoke. My mother has tried similar things with me with sugar. It hasn't worked out great, but we will leave that aside for the time being. But this is the law that we have. The argument put forth by the investor, and boy, you have to credit creative arguments. Our trademarks are being violated. We should be able to advertise our name the way we want. Among other things, I'm simplifying it, but that's the argument put forward. And the question is, do the plain packaging laws in Uruguay violate the fair and equitable treatment standard? Right? What is fair and equitable treatment standard? We describe this as pornography. Not literally, but by the US analogy, right? You kind of know it when you see it. It's kind of problematic when we let people award millions and billions of dollars on, do you think it's gone too far? And you see a divergent view here. The majority tell us, no, states are allowed to regulate. The dissenting arbitrator, one of the most respected American arbitrators who lives in the UK, who has written 3 very famous books, you all know who I'm talking about, the big blue books, tells us no. Right? And you can kind of get the reasoning. One tells us states deference, the other tells us, well, these are rights. Again, you're seeing this area of tension. What do we do about this? Now, before we step on the 2 things I want to talk about, why does this problem happen? Why do we see decisions coming out this way? Why are we not seeing tribunals really getting human rights scholars, getting law of war scholars to comment on these decisions? These awards tend not to do that. They tend to look at these fairly through a commercial lens? Why is there not better engagement? One thing is tribunals, this comes from a legitimate, something that most arbitrators would tell you. We do not want to exceed our authority. We have been mandated under this consensual model to decide a commercial dispute. If you're asking me to decide human rights, if you're asking me to fix all the problems of the world, that's going a bit too far. So there are these jurisdictional and applicable law arguments that come up. The other thing is, why don't you allow counterclaims, right? If you want the system to be more fair, I'm saying this, allow the other party to say, but the environment and invoke environmental law. That has not worked out great because tribunals have read counterclaims for the most part fairly narrowly. Could they do a more expansive reading? Probably. But our current jurisprudence more or less takes a narrow reading of the thing. Tribunals don't want to, again, I think it comes from a good place. We don't want to fix every problem on the planet. This is our mandate. But these two seem to be limiting factors for the tribunal to be addressing points of tension. Okay? Now, let's take a little bit of a look in history. This is a little ISDS focused, but I think it is interesting to tell us. 1959, a very significant year, because in this year, Pakistan, a country that has existed now for just a little over a decade, right? 1947 independence, 1959, signs its first agreement with Germany, giving rise to this new area of law. Pakistan gets sued in the early 2000s, right? A Swiss company, SGS, brings in arbitration, and the Attorney General of Pakistan, today a very prominent, respected arbitrator, goes to Google and puts in the words, what is a treaty, what is ICSID? Okay? And then he starts investigating what negotiating history can I find for these treaties. Guess what he finds? Nothing. He tries to figure out who was involved in signing these treaties. Guess what he finds? Nothing. And when he starts asking other agencies, why are we signing these treaties? The answer is, well, a delegation was coming into our country. We needed to do something. Why not sign a treaty? Which generally seems like a good idea to be entering into legal agreements, but that's how a lot of these treaties have come into force, right? They came into force by states not appreciating that what you are signing is actually an enforceable legal document with rights that somebody can actually invoke against you. And a very famous political scientist, Lauch Paulsen, actually studied this phenomenon, and he's written, you can download his thesis for free. He became an OBE last year, so well done you. But his thesis is called Sacrificing Sovereignty by Chance. And the framework he came up with, this is bounded rationality. You make your decision based on what you know, and if you were believing that these were just statements of good intents, to be fair, if you read some of these treaties, it does have the formality of a treaty, but they do use loosey-goosey language, right? Fair and equitable treatment. And if you ask a state negotiator, they believe, of course, that's what we do, right? Until you get sued and then you realize, my God, these documents really have teeth. But this is the explanation, that you didn't know how potent some of these agreements could be. Okay. Just to get this out of the way, The world wants to fix the problem. Again, 99% of people think there is a problem, we have to do something. So 3 major reform movements are taking place. You have Working Group 3, you have amendments to the ICSID rules, and then you have European vision for the world. That is, let's get rid of arbitration altogether, and let's put together a WTO-like court mechanism. For any trade lawyer in the room, that system has worked awfully. It was almost non-existent, the WTO body, for almost 3-4 years. But that's what we can aspire to. This is not going to fix too much, okay? Helpfully, in a very early meeting of the Working Group 3, the states decided themselves, leave all the substance aside. We're only going to think about procedure. It took, 5 years, Mercy, to come up with a rough template for a code of conduct for adjudicators?
Final version.
Pending?
5 years, yeah.
5 years. Okay, so time is relative in state time, but that's where we are. This is going to, at best, give us procedural improvements. We don't know what Europe is thinking about. One thing we do know, the United States, probably one of the most polarized moments in American history, although just to be fair, there was a civil war. So that country has had a rich legacy of not agreeing on things for a very long time. But we're definitely at a polarized moment in US history. A country that used to be very pro-arbitration has done the impossible. We have got both the Republicans and the Democrats agreeing that arbitration must go. Right? Now, very different reasons, but you really have the Democrats and Republicans agreeing that arbitration has to go. One of the key players, therefore, supporting arbitration is out of seat. This is really putting a very active player today, therefore, is the European Union, because they are very adamant that arbitration has to go. If you really do want to think about somebody who's going to potentially pose problems, it is in this continent. Okay? But just note, we're concerned with procedure, we're not concerned with substance, any of these. Now, the institutions are doing the best that they can. We must appreciate that. But this is not going to fix any of the meta questions around us. Now, what should we be doing? This can be a 3-day presentation, which we will not do. There is apparently a pretty nice reception. But I do think when we are talking about other areas of law, it would be better for the existence of arbitration. Remember, this is a dispute resolution mechanism that survives when people believe in it. It's kind of like Tinkerbell. If we believe in arbitration, people will put it in contracts. And this is the challenge facing us, right? Constituents don't believe arbitration is the most effective form for resolving disputes, right? The more we can get away from this is a dispute between Mandy and me, and it only concerns Mandy and me, we're likely going to do better, right? So states have a role to play. The tribunal has a role to play. In investor-state context, the investor has a role to play. Politicians have a role to play, right? Working Group 3, the key player in that room is states, right? Others can sit in. You're free to speak if they give you the mic. That's one of the wonderful things about freedom of speech. You can say what you want. We'll do with what you speak what we deem appropriate, right? And there's the public, right? A couple of years ago, I think this was 2015, so pre-COVID, I happened to visit in Germany the town of Mannheim. just out of curiosity, has anybody been to this town of Mannheim? Good, please don't go there. There was nothing impressive in that town. It's a tiny little post-war industrial town, right? The only impressive building is the university, which used to be a palace, and that's where we had our event, this event. This tiny town, the public square, there was one of those giant unicorns. Abolish arbitration, abolish CETA, abolish TPP. Right? These were the mega treaties being signed. Just do want to point this out. Sometimes we don't realize what a key role these other stakeholders can play on the existence of arbitration. But if a tiny industrial town feels that arbitration is a problem, the German politicians are going to feel obligated if they have to run for elections to do something about it, right? We need to be considering everybody. Now, I am going to, for the purposes just of the presentation, point out some things that states can do, and this is by no means exhaustive, and some things tribunals can do. And I just do want to point out, if you don't have an integrated approach, these individual fixes don't take you very far, right? Now, you can just see some of this. Now, why is this important? Something we are taught in contract class, something we're taught in public international law. Say what you mean. It's your contract, it's your treaty. Do a better job about it. Most of these treaties were drafted very poorly. I had the misfortune of having to read the Netherlands-India BIT, which was a cut, copy, paste clearly from 2 or 3 treaties, because there were provisions that just didn't make sense. They're cross-referencing things that don't exist. It's just a treaty, who cares, right? But take your treaties, take your contracts seriously, keep them on a sensible path. Now, some things we are told to do, right? We are told these treaties take away rights. So you should preserve your rights, and a good place to put them is the preamble, right at the beginning. Better to do this than not to do this. I just do point out, tribunals have not always taken preambles very seriously, right? It is an aid in interpretation, and different tribunals may or may not ascribe the weight that states may think they have accomplished by putting some of these protections. We are safeguarding our rights, health, in the preamble. But that's one solution that's given to us. Put non-relaxation standards in your treaty when investment is being admitted. We're not going to relax labor. We're not going to relax environmental standards. Again, you would think it's a good provision. It is inappropriate to encourage investment by relaxing health, safety, environment, right? This is a great, great provision for states. When tribunals are given this provision, they look at it and tell us, well, your obligation here ended when the investment had to enter the country. Once the investment is in the country, this clause has died. Right? This is one of those instances. Perhaps say what you mean a little more clearly. If you wanted them to live throughout the treaty, say that differently. You can put general exceptions or non-precluded measures if you want to use the fancier term. Okay, and this is something like this, right? Nothing here will prevent the adoption on a non-discriminatory measure, and then put in values you think important to protect animal life, to protect environment, living resources. This is something, when Catherine had mentioned, you did trainings with governments, you would really tell them, put these in if you really want this to be an enforceable obligation. And you really thought things were going fine till the worst decision in the planet came out about 2 years ago, Echo Oro versus Colombia. Echo Oro versus Colombia If somebody can explain this case to me, I will be very grateful. But this case essentially tells us you can carve out things from liability, but you haven't expressly carved out liability for compensation. So you may still be obligated to pay money. It hurts my mind a little bit to think that somebody can be owed money without a finding of liability and the decision on liability. I mean, this is things that we fail first-year law students for. But that's the decision. We don't have the decision on liability yet, so there's a little bit of hope for humanity. But this sentence out here, the investor is not prohibited since you haven't excluded money, which you would think is an obvious consequence of this clause. They can seek money, is where we are today. Which is my whole point, you can do individual fixes, but until we don't change the way we are thinking about some of these issues, you're not thinking about them thoughtfully, we may not go very far. Now, this is a provision that tells us keep a check on cases and address your treaties in light of cases. This premise moves on the assumption that state officials are going to read these big arbitration awards that come out, and then they're going to keep putting clarifications. The Maffesini decision on the MFN, the most favored nation clause, comes out. A lot of states thought this was problematic, and they started putting the MFN exception. We are not going to follow the Maffesini reading. Getting state officials to focus on these, as a person who is an arbitration practitioner, reading these awards along with the Geneva Convention, these help with sleep. They're big and boring. Now you're expecting state officials to be abreast of all these decisions that seem to be coming out pretty rapidly and actually addressing them. You have to actually put them in treaties or put them as clarifications before a dispute arises. I think is putting a very heavy onus, but this is another obligation. I'm going to very quickly just try to point out what tribunals can do. I know I want to end on time. So can tribunals look at areas of law outside the treaty, outside the pure contract? And actually, the Vienna Convention on the Law of Treaties does allow us to do that. Right? You can look at Article 31C, which says when you're interpreting something, look at all relevant rule of international law applicable to the parties. Now, it's a little awkward. You're going to have to apply this by analogy because the parties are generally countries for a treaty. One of the party here is the investor, but by some legal analogy, I think you could apply it. And this does give the tribunal some mandate to go beyond the instrument in front of it and look at broader human rights environment and try to put them in. Think about them. Adopt the Vienna Convention. There's this meta question that human rights scholars often ask us. Will the tribunals get it right? And my answer to that is, if we can trust them to figure out billions and billions of dollars in disputes, I think we can trust them to figure out human rights. And if they find human rights difficult, if you find the environment, if you find climate change difficult, appoint experts. You can do that. Get in people who can advise you, just like how they would advise you on a construction dispute or on a financial issue. Get experts in. Let them advise you, make a reasoned decision. Welcome amici submissions. Now, this is an area of improvement. Most instruments today allow you to consider amici submissions. There is a mechanism to allow it. What is problematic is we don't know what role they play. In fact, if you look at most awards where amicis have been admitted, you really don't know if the tribunal even looked at it or read it. And this might be something we just want to suggest, look at them and just consider them a little bit deeply. You may get insights that might be lost in the battle between Mandy and me. Look at everything that's happening around us. Working Group 3, UNCITRAL. There's a sickening amount of statements that are made by states that are all but publicly available. Third thing, if you don't have sleep in the night, you can browse through this and look at them, but that can give you some suggestions, some ideas on how we might be able to make our system better. And I mean, just to point out the obvious, the arbitral system works on people earning by the hour, so there's a little bit of reluctance to give something up, but you can always defer it to other international bodies. If there is a human rights issue that you know involves a meta question, you can go to the competent body and ask them to give an opinion. That is possible. The other body may or may not agree, but there's no harm in asking. You're building in legitimacy. And this is, I think, a good point for us to end. We're probably at a moment where most people are looking, especially at investor state, but it's a question of time that it's going to follow into the commercial arbitration space. That's how the debate moves. Where most people see a problem with it. Most people do not think it is a legitimate form of dispute resolution. This is consensual. If we, as people who like this and believe it is a just and fair system, do not respond to some of these tension points from other areas of law, we might find ourselves in trouble. So I think let's work harder. Let's try and see how we can integrate other areas of law better into our system. With that, this is funny, and I will stop here. Thank you.
Wow. What a wealth of knowledge. I normally can take notes quite quickly, digest quite easily, but you blow me off my feet. Congratulations, Dr. Duggal.
Thank you.
The presentation was exciting, knowledgeable, funny, but very, very inspiring. My name is John Bassey. I'm the president of the global president of the Chartered Institute, and it's Q&A time. I know we're up against the clock, but let's start with questions from the floor. Questions?
I think there's a question, right?
Can you identify yourself, please, sir, and then?
Yes, thank you. James Sanchi.
James.
That was an excellent presentation, very exciting and thought-provoking, very fluent as always. Some 8 years ago, 2015, the late Johnny Vida gave his Alexander lecture, in which he addressed the perception at that time, which continues, as you have quite rightly pointed out, that ISDS was not working, that there was hostility to it. And he said, arbitration can't do everything.
Right.
And I wonder whether there isn't actually a concern which has grown since then about that. You have focused on ISDS, which represents less than 0.5% of international arbitrations, and a vanishingly small percentage of the fellows of this institute have any involvement with it.
Right.
And some of us are really concerned about the reputation arbitration as a whole is receiving in the general public, but we want to get on with our jobs. Do you think there might be another possible solution to the problems which you have raised, which is actually for arbitration to back out of this space altogether?
I think I should be good. That's a great question. couple of reactions, and I would love to hear your thoughts on this. This is a very small set, you're totally correct. But a very loud vocal critique of arbitration at large. You know, in our minds, the distinction between investor state and commercial is so clear. These are different areas, these are different institutions. For most people who are looking about, who see the press headlines on this issue, they're not seeing this nuance. They're seeing one word: arbitration. So, I mean, I think the problem is here to stay. Can we get rid of it? The answer to that would be abolish treaties altogether. Because as long as treaties are going to exist, one side is going to invoke treaty rights, one side is going to invoke broader principles. That's just the nature of the game. A state is going to point, I am doing this often for public benefit, for the environment. These other areas are going to get in. Now, there is a group of people who believe that this system should be abolished altogether. It is a very small minority, a vocal minority, often from non-profit groups that look at this system as not being legitimate. But it has still not entered into even the European Union doesn't tell us, let's get rid of treaties. Their real solution is, let's get rid of arbitration and get a court-like structure in place. That's going to fix the problem. I'm afraid that unless we get rid of this altogether, the tensions are going to persist and arbitration is going to get a bad name. We could as a bar try a lot harder to change the perception and put out statements that requires people to want to read it. You're a very specific person who is not a lawyer / arbitration practitioner that would want to read a press release on arbitration. I'm sure there is a subset of people who want to do that, but a really small subset. I don't know, therefore, in the absence of us abolishing it altogether, whether we really have a better solution other than engagement, I'm afraid. And I think this is why I really do look at it as an existential issue, because if these problems keep persisting, the cries for getting rid of arbitration are only going to get louder.
Asi, any questions from the online?
Yeah, hi. So I just want to remind everyone that's listening online to please, if you've got questions, to please put them in the chat so that I can read them to Kabir. We've got a couple coming in, but preliminarily, I wanted to ask you something. So recently, I was at another lecture where, and I won't name names, and I won't say the countries.
Later. That's gossip, and that's fine.
Over drinks, right. Where a story was told about a particular country where in court, an investor tried to use the local litigative process to assert their rights. There was a lot of corruption going on. There were a lot of human rights violations going on, and the local judiciary were facilitating this. And when the local judiciary gave their final ruling, which poured out the investors, one of the government attorneys said on the record, like off the record, to this well-known arbitration practitioner, thank God for ISDS, because now the investor can file an ISDS claim against us to basically to hold us to account for allowing these human rights violations. So what do you say in response to stories like that?
Thank you for sharing that, because I think in the loud noise about everything wrong about ISDS, and there is a lot that does need to be reformed, the actual purpose was for instances like this: rule of law, human rights, values that I think as decent people we think are worthy of being protected. You're going to have, the world is probably going to have to do a better job of showcasing these voices. let me make a broader sociological observation. This area of law is about 20 years old, right? It's happened in my lifetime. I'm not 20. I have seen the system grow, right, from the 2000s with Argentina till where we are right now with Spain. So it's a relatively new area of law. And we did in the early days of this 20 years see a greater willingness to expand these concepts, to give them teeth. With all the backlash, arbitrators are themselves becoming a lot more cautious, a lot more skeptical, a lot more reluctant to step on the authority of state. So in a case like this, today I would not be surprised if a tribunal comes out saying, well, you decided to go to the court and that was your choice and good luck. But I do think the system was created actually for situations of that nature, right, where you really felt mechanisms were going to fall short and you needed an avenue for justice. Ooh, this is pressure.
I just wanted to congratulate you, Kabir. Excellent presentation. And just to take you on a couple of points which I think are very interesting, which is if the system is to go, treaties would go. What would you say about the Brazilian treaties that take out the arbitration option in terms of investors and follow a state-sponsored approach? Let's say the big brothers are fighting together, and the state then would sponsor that one way or the other. They have a joint committee, as you know, you're familiar with those treaties. So that's one option. The other is, I think the answer is very simply, historically, ad hoc and permanent systems have coexisted. The ICJ, the WTO, and you referred to those, and arbitration was never eclipsed by the very presence of permanent systems. And in fact, many of those have proved dysfunctional for various reasons, and arbitration continued. And I'm not saying that because we're all speaking in the same room as arbitration practitioners, but the reality is, ever since gunboat diplomacy and beyond, that was the answer. And even now, the backlash we're seeing, I would say it's cyclical. It's a cycle that you face. And then eventually, back to point one, where arbitration, everyone be embraced by everyone. I think the reality is, when the big players started being sued by the others, they said, oh, no, that's not the game we were playing. You were meant either to sue each other or we sue you. But now being sued, and we've seen that specifically within the EU and beyond. So what would you say about then the Brazilian model? Do you see that as a successful model? Would that fly off the ground, or does it simply transform arbitration from an investor-state arbitration to a state-to-state, purely public international law arbitration?
Thank you for raising that, because Brazil does give us a big counterexample. Now, a few reactions. The Brazilian model is reviving the 1920 approach to dispute resolution, right? Diplomatic protection was the method of resolution. So if you were a foreign investor, you had a problem, you went to your country and your country espoused your case. That's kind of what Brazil is telling us today. What can we say about this model? Well, we can say Brazil has not had a single case to date. There are about 12 treaties that exist. None of them have been utilized. The treaties have innovative ideas. They're barely fleshed out. So they have not really been tested. Some of these meta questions, right? Because the treaties work in this really beautiful manner. If there's a dispute, Brazil and India, right? They are a country that have signed it. Brazilian representatives and Indian representatives are going to get together in a room. They're going to talk and they're going to try to resolve the dispute. Can you get to the Brazilian office? Can you get... That was the problem, right? That existed. What did the little person do when they had a dispute? Do you have access to the states? Now, arguably, you can create mechanisms, and a lot of these ideas sound like very good ideas till you really try to implement them and then realize a whole host of issues that come up. And I think that's what we're going to see with the Brazilian model. I do very much like the point that you were making, that there was some fundamental inequities in how these treaties were negotiated. Part of my doctoral research is looking at US negotiating treaties. And the US was very clear in its mind what it was getting from all these other countries it was negotiating treaties with, in ways that probably a country like Pakistan didn't know. So there is a fundamental inequity, and it is very entertaining to see how the developed nation, looking at a country like US, that has been such a prominent supporter of the regime, is really taking such a critical assessment. Joe Biden had put forth anti-arbitration statements in his election campaign. It was significant enough that he felt it had to be a point that was made publicly available. TBD. I do think this is different, though. I do think countries are walking out, countries are being a lot more skeptical, and that does look different from other moments in history.
Dr. Duggal.
Yes.
I have a question for you.
Yes, sir.
Taking it on a different angle. Are arbitrators, or do you think, are arbitrators equipped to address climate change and international humanitarian law issues?
In a room of arbitrators, I think the answer is yes. I'm kidding. See, this is a question that, one of my areas of discipline was human rights law. And actually, human rights professors expressed a lot of skepticism in allowing tribunals to make findings, because the fear was they are going to get it wrong, and it's just going to create a very troubling regime for us. So there is skepticism on that point, and a justified skepticism. My own answer to that, though, is human rights is an area of law like any other area of law. And if we're ready to empower tribunals to decide very complicated construction issues, very complicated issues on engineering and technical areas, you don't expect your arbitrator to know how a laptop is made, but you expect them to get the right skills by all these different techniques to resolve it. And I think this would, James, getting back to your question, this would probably not solve some of the criticism, but I do think it'll make the process more legitimate, right? The argument today is you don't engage. Now, they may not like the answer. Ultimately, there will always be one losing party. That's the happiness / criticism of arbitration. One party is going to be upset and everything's wrong, but at least you have engaged. So from a legitimacy, a macro perspective, things are better.
Thank you, Doctor. Anybody on the floor? Marcy?
We have a couple of questions coming in online. I'm going to read a couple together because they have to do with enforceability of awards. So Derek Bruce is making the comment that he can't see how arbitration on matters such as breaches of international law around harming the environment could ever see enough buy-in to make arbitral decisions strong enough to give appropriate remedies. And I read between the lines to sort of see, too, the issue of if you reach a point where we are enforcing higher, stricter standards of environment treaties and climate change treaties, would that not give the states yet another reason to criticize the process and potentially not use it? And then we have another question here from Jeffrey Beresford Hartswell, who's an arbitrator, and he says, how does arbitration enforce rights with no coercive ability? Surely only the national courts have coercive powers. Arbitrators only express opinions.
I think to both of these questions, if a party is going to come in front of you and tell you there's a human rights issue at stake, if a party is going to invoke it as a right, a defense, or a counterclaim, it is then a live issue in front of you. Now, the current approach for a lot of these issues for tribunals is to dismiss them. A lot of these do have obligations. You know, I mean, I wasn't fully certain if the question was that these don't have very firm obligations. They don't have coercive powers under these agreements, but that's why you're bringing it in front of a tribunal to decide this as an issue, just like you would decide any other issue. I mean, I think it's squarely within the dispute realm. Whether you want to engage with it or not engage with it, that remains another question. But it is in front of you. I mean, what is your prototypical ISDS case? State has done X. Investor says it violates my rights for this reason. And the state is invariably going to invoke some meta question, right? Environment, human rights, well-being of people, as its defense, right? That's your prototypical ISDS case. It's now in front of you how you engage with it, what you do with it, how you lead the arbitral process. What we do as tribunal members is up to the tribunal. But it is a live issue. Did I miss any part of the question?
Can I ask another one?
Yes.
This is slightly different on the complementarity. You talked about integrating.
Yeah.
Shantanu Kanade asks, what about other mechanisms? What about integrating other mechanisms? Yeah. Could mediation be used as an alternative or at least a complementary mechanism?
Could mediation be used for resolving disputes? The answer is unequivocally yes. The same criticisms we hear about mediation would apply in the ISDS context, probably with a heightened scrutiny. Right? The big reason why mediation, most of the treaties tell us, states you have to negotiate, mediate for 6 months, 8 months, 12 months, as in pick your favorite number. India's put domestic remedies 5 years, but 5 years in India is not a lot of time. That was at least passively funny. But most treaties do give us a magic mediation period. It's not worked out great because it's generally not a good look for politicians to be giving a foreign investor who's often not very popular a lot of money. That has been your typical paradigm, right? The state official might get prosecuted for corruption, for bribery, and just it's easier to say there's an award, we got to pay it, than I'm voluntarily giving somebody who's often not popular a lot of money. ICSID's offering us a new mediation mechanism. We now have the Singapore Convention. They definitely have made better strides. The world would be a better place if we all mediated disputes more. But that is Uncle Kabir's free advice for the day. I have no empirical basis to say that, except if people can resolve things without getting into a I hate you and you should die war-like situation that arbitration tends to become, things are just nicer. But again, there is no empirical basis except how I would like to see the world for that. Did Uncle Kabir's words of wisdom inspire you? You have a very mischievous smile.
Dr. Duggal.
Yes.
Do you think that the global reform processes that are in place right now will address the backlash against arbitration?
The global reform mechanisms will make procedural fixes, time and cost seem to be big things. A good ISDS case takes 4.5 to 5 years. That seems problematic. So some of those may get better. The idea about ICSID arbitration was to help the little person, right? That was the idea. If you're a big, powerful corporation, you could get Rishi Sunak or Joe Biden's attention. It was the little person, how to protect them. But these cases, on an average, cost between $5 to $15 million. And that's money I don't have in my bank account. And I suspect a lot of people don't have. Again, this is a meta question, right? If we want arbitration to be effective, we need to be thinking about that. So we may see improvements there. It's substance neutral or substance silent. So those problems are going to persist, and there are lots of problems there. So Exciting time to be alive.
Can I ask the question now?
Oh, I'm so sorry.
That's all right. In your opinion, in Sri Lankan situation, is the arbitration or the mediation is the most appropriate technique to solve this problem? Because some people said there's a terrorist war, some people say it's a civil war. And there are so many other areas of this, it's not very clear.
See, one reason why arbitration becomes attractive as a method to resolve dispute or just any of these international mechanisms is that it kind of takes the dispute out of what may be a very charged political climate domestically, right? You may not be able to get people within Sri Lanka to agree on how you describe this process. And that could be fundamentally unfair to one group or the other. Getting it out to a neutral body often had the advantage of offering a better solution. Now, I will add an unrelated but I think important point. Most of the international arbitration, and I think this is true both for commercial and investor state, does tend to look, sound, and behave very specifically. I'm not going to use the phrase PMS, right? That has done the rounds, the da, da, and da. But there is some truth to that. We would all do better by making arbitration more representative, by getting in women, by getting in different voices, different accents. It's again just going to build greater legitimacy. So these would be my two reactions. Internationalizing is good, but really internationalizing. It does look kind of neo-colonial today, not going to lie. I think people want drinks.
Yes.
There was consensus. There was
One more?
one last, okay.
If we have time, we can do one more. That's coming online. David Adiyami Abere asks, Dr. Duggal, you said that if arbitrators can rule on multi-million-dollar disputes, they can rule on human rights disputes. But doesn't this view overlook the importance of the identity of the decision maker and the impact this has on the legitimacy of the rulings, especially in a human rights arbitration when it's not likely to be consensual? And I would follow in with that, generally speaking, do arbitrators have the capacity, are they equipped to address climate change and international human rights and these types of substantive issues generally?
So let me give two reactions. Could the identity be a lot better? I think the answer to that is yes. It's shockingly, looking at the US, Mercy, and this is something both of us at least can talk about. Women have been participating since 1999. So we now have a sufficient track record, because we're often told we have to wait for one generation to retire or die, which is generally a shitty way to be looking at things, and things are going to get better. But this is my point. Since 1999, women have been either equal or higher than men at law school enrollments. Look at the US law firms. That is not reflective of how law firms operate. It's still very specifically one gender over the other. So could we do better? I think the answer to that is undoubtedly yes, we should do a lot better. I don't think the idea here for arbitration is, let's take a pure human rights issue. I mean, the areas of tension really is when there is a commercial issue and a human rights issue being invoked in parallel, what do you do? Right? Human rights does give us avenues to raise human rights issues. Parties may want to bring it in front of an arbitral tribunal because you can actually get something out of it that has teeth. But the situation I'm talking about really is this area of conflict, this area of clash, where one party is saying commercial, one party is saying broader. How do we deal with that? And that you're going to have to deal with that because that is the paradigm we have. Are tribunals equipped? I'm going to get back to my same thing. If we believe they're smart people, we have to trust them. Will they get it wrong? Yes. Do judges get things wrong? Yes. That's kind of the price we pay, but hopefully we will eventually move to a point where we get it right. I mean, I think the thing right now is we don't want to look at that. We don't want to engage with that. And that seems problematic because a lot of people think, no, these are worthy issues that you need to be thinking to come at the right commercial decision. I do think we should be thinking, therefore, about that.
Well, I think I'll take Dr. Duggal's cue. I think everybody's a bit thirsty right now.
I am certainly.
And I'm just going to take a couple of minutes just to wrap it. I'll keep it very simple. I mentioned exciting, knowledgeable, inspiring, those sort of words. But beyond that, it is truly a gift when someone with such education, understanding, and insight can break down such a complex subject in less than an hour. Thank you. I think he deserves a round of applause for that. I go further. Dr. Duggal has given us a wealth of knowledge and a direction and an approach that at the very least will cause us to pause, including me, before we go charging off after the next dispute resolution mechanism, ensuring that at the very least we are able to protect and preserve rights with the tools that are in our tool bag. Let's continue to educate ourselves. Let's continue to discuss. Let's continue to arbitrate. And of course, let's use the practical advice that you've provided us with, Dr. Duggal, and thank you very much this evening. I would also, just before closing, I'd like to thank everybody online who's taken time out to join us. I want to thank Marcy. I'd like to thank Catherine and all the other members of the team, Nikki, our great WorldSpan group, the caterer, and whoever's providing the drinks. Thanks in advance. And, of course, thanks to you, our in-house wonderful audience. Thank you very much. Have a good evening.